So it's an interesting topic today.
I think
Should
so.
should we hear what the kids want? And if you think about the premise, um, for those outside of family law, they might think, why would we want to hear what the kids want? We want kids to brush their teeth, go to school, do their homework, follow their parents' directions. But in the field of family law, we spend so much of our energy trying to arrive at a fair and reasonable outcome, mainly for the benefit of the children. And yet, at the same time, rarely do judges, lawyers, or mediators meet or hear from the children. And in fact, we arrive at conclusions and opinions without any input from the children. So the topic for today is, quite frankly, a interesting one, because here we are decades later in the field of family law, still asking the question, should we hear from children? So why don't you tell me, Leanne, what do you think about that question?
Well, I think it's an interesting one, and it is one that comes up a lot. And, um, one of the reasons why children are generally kept out of family law matters is because it is considered adult conflict with adult issues, and it can be very traumatic for children to get put in the middle of the conflict going on between two parents who they love. And, they shouldn't be put in a position where they feel that they're, having to choose between their parents and perhaps hurting a parent. Children don't need that sort of responsibility on their shoulders. And so it is a tricky issue because, in some cases, children's input can be helpful and it can be, valuable. And, particularly, as I'm sure we're going to get into, as they get older, perhaps that what they have to say, is even more valuable. But at the end of the day, I think parents always need to remind themselves that they are the adults in the matter and they are the ones who should be making the decisions, and children should not be making decisions with respect to any of the issues in their parents' family law matter.
So let's take our viewers back a step and let's actually set out what the law is on this very subject. And then let's take it one level further and talk about what happens in practice above and beyond what the statute says. So in Ontario, there are two statutes that go to the subject of custody access and parenting schedules. Federally, there's the Divorce Act, and the Divorce Act specifically provides that the decision with respect to parenting of children must be based on the best interests of the child test. And the best interest test is often defined as a whole list of factors. But in the provincial legislation, the actual legislation governing parenting plans and parenting rights in the provincial legislation, called the Children's Law Reform Act, is found in section 24 of the CLRA. And I'm going to just jump right to the subject matter of today, which is the voice of the children. And in section 24 of the Children's Law Reform Act, it lists all of the factors that lawyers, judges, mediators, counselors, and assessors take into account when determining what is in a child's best interest. And so, for example, it talks about the children's needs, their age, their stage of development, the history, each parent's willingness to be able to care for the children, talks about family violence. But as it relates to the topic of today, section 24 sub 3 sub E, as an elephant, of the Children's Law Reform Act says the following, quote, factors related to the circumstances of a child include the child's views and preferences, giving due weight to the child's age and maturity unless they cannot be ascertained. Now, for those of you that have heard me say that, that's a change to the previous law, which not that many years ago said the court is to consider the child's views and preferences if they can be reasonably ascertained. The legislation changed to say that you must include the children's views and preferences. You must give weight to them based on their age and maturity, unless they cannot be ascertained. So it's a reverse onus, meaning you must take into account the children's views unless they cannot be ascertained. And this is not just semantics. This is actually very important, because it's raised the importance of the child's views and preferences unless a judge decides, no, we can't take that into account. They're not mature enough, they're not old enough, and we cannot reasonably ascertain it. So that's the law. So in practice, Leanne, why don't you share with the viewers in what situations would we actually ask the children for their views and preferences, and how does that happen?
Well, there's a number of situations, and certainly where parents are not agreeing on a parenting schedule or decision making. I mean, in cases where the parents are more or less in agreement, then that's easy. There's no need to get the children involved in that. But certainly in cases where parents are not agreeing, it can be important and helpful to get that information from the children. And so the question comes up, well, how is it done? Well, it is not done by Steve and I sitting down with children and interviewing them about their preferences. Children need to be handled very carefully because of their young age. And so some of the methods that can be used in order to get their input and ascertain their thoughts and if they have preferences, one of the ways is something called a voice of the child report. And so in that case, the parties can agree, or it could be ordered, that the children meet with someone who is properly qualified to prepare a voice of the child report. And people who are properly qualified, often they come from a social work background, a counseling background. They may be a mediator. They may even be a lawyer. They come from various backgrounds, but there's specific training that they have to have. And they meet with the children. Usually one of the parents takes the children on one occasion and the other parent takes the children on another occasion. And they will interview the children, and based on their interviews, they will prepare a report about what the children have said. And the limitations of this are that the person preparing the report, they don't have the time, because they're not being paid for it in this situation, to go into an in-depth analysis of what's going on behind the scenes and whether the children are being influenced. They can, raise it as a flag that this may be happening, but they can't usually offer too much commentary on it. They're really just interviewing the children and putting forward their preferences in the matter. Now, another way that the children's input can be obtained is through a Section 30 assessment, which is a much, much more in-depth report that is.
And for the benefit of our viewers, it's Section 30 under Section 24 that I just mentioned of the provincial legislation called the Children's Law Reform Act. So you're welcome to Google Children's Law Reform Act Ontario, read what I just told you a few minutes ago about Section 24, and then read what Leanne is about to explain right now at Section 30.
Yes, and so a Section 30, again, it's something that can be ordered by the court, or the parents can agree on it. And the person who does the Section 30 assessment is usually a psychologist. There's somebody who's got specific training in this area, and it's a much more in-depth analysis of the parenting situation and the home situations. It's done over a much lengthier period of time than a Voice of the Child report. It involves multiple interviews, and it is much more thorough, but it is also a lot more expensive. So that's, sometimes depending on whether you want something quickly or whether you have the time for something more thorough, and cost is an issue. That's where, there's differences in why you would ask for either item. The other thing that I haven't mentioned is the Office of the Children's Lawyer. And that is something that quite often in cases involving parenting decision-making and schedule disputes, the parties can agree, but you need to have the court order it either on consent or otherwise. And the Office of the Children's Lawyer can get involved in, they can do a voice of the child report, they can do an actual in-depth section 30 assessment, they can do a variety of these things that involve, again, meeting with the children either for a very short period of time if that's what the report is for and the parties have a limited period of time, or it can be lengthier and more involved. So those are the main ways that we can as lawyers and in the court involve the children in the process.
So you've done an excellent job identifying the methods in Ontario of how lawyers, parents, judges, mediators are able to access the information accurately and reliably with respect to what do the children want in terms of their parenting schedule with each parent after they separate. What I'd like to annotate on those three options, and just to recap for our viewers, there was the Voice of the Child private report, there was the Section 30 parenting assessment, and thirdly, there was the Office of the Children's Lawyer. I'm going to take it in reverse order. The Office of the Children's Lawyer is a department of the Ministry of the Attorney General. They operate off of our tax dollars. And if a court case is underway involving parents who are divorcing or separating, and if a judge were to order a referral to the Office of the Children's Lawyer, and then after that order is made, if the Office of the Children's Lawyer accepted the file, and note the various stages for this all to occur, there needs to be a court case, there needs to be a request made of the judge to make an order referring, the judge then needs to accept that request, make that order, and then the OCL has to receive the order, receive the intake forms from both parents, then decide if they will accept the file. And if all of that happens, then the OCL will accept the file and then will decide whether they will provide a clinical investigation, which is more of a fulsome investigation of what the circumstances are regarding the kids, a review of all of the collateral sources, teachers, doctors, parents, relatives, and the interview of the children. Alternatively, the OCL can only do a Voice of the Child report. In other words, it's the more abbreviated version. In both cases, it's free of charge to the family. If you go the route of a private Voice of the Child report, it's often done by a social worker or a psychologist. The cost for that is between $3,000 and $6,000 more or less. And you get effectively the same report as you would if you got a Voice of the Child report from the OCL, from the Office of the Children's Lawyer. And that report is court admissible, and it could be relied upon by a judge in order to determine what the parenting schedule should be, and for the judge to also decide if the report will be relied upon and how much weight can be placed upon it. No surprise here. A Voice of the Child report of a 14-year-old is going to be given far more weight than a 5-year-old. And the Voice of the Child reporter will likely also indicate in the report the level of reliability, meaning how many times did the interviewer ask this question, how they asked the question, was it done through drawing pictures? Was it done through direct communication? Was it done by Zoom? Who was in the room? Which parent brought the child to the meeting? If it was done by Zoom, in which home was the meeting? So these are all factors that could determine the level of reliability. And lastly, the Section 30 assessment. They still happen. They're in high demand. The assessors who provide a comprehensive assessment are very few. They're very expensive, anywhere from $10,000 to $50,000. Yes, you heard that right, $10,000 to $50,000. Those reports generally take 3 to 9 months to complete, and they are comprehensive. They are very detailed, and they tend to be the ones that are given the most amount of weight by judges because of the fact that they are that in-depth and that comprehensive. So that is the annotation in terms of the cost and the level of depth of the different types of assessment. But now let's go backwards and say, talk about in practice. Where does this happen? How often do we actually reach for the children's views and preferences? Leanne, why don't you give us an example?
I mean, I have a number of active cases where we have sought, one of those three. The Office of the Children's Lawyer is the most common one because it is free. People are more liable to choose that option if they can, and it's not just up to them. Obviously, the judge must order it, and then the OCL must actually agree to take on the matter. So it's that can be the issue. They may decline the matter, but I also, I've had a number of cases, many where we've gotten voice of the child reports, and then a smaller number where we've had the Section 30 in-depth assessment. And there can be advantages and disadvantages for your client as well with these different options, because there could be things that come out that are harmful if your client is seeking a full decision making, or wants to have the primary residence, or even maybe when they're looking for 50-50, but there's reasons why that shouldn't happen. This type of information, it's very hard to dislodge the recommendations of a properly done Section 30 assessment done by, a qualified expert. So, it can, in terms of the strategy of the case, it can sometimes be, a situation of deciding, is that going to be helpful, or not to your client? But having said that, if the other side is asking for it, it's also very hard to take a position and say, well, no, my client's not consenting. And I'm curious, Steve, if you've had that come up where, opposing counsel is asking for, one of those three things, and it's, perhaps a high conflict, case. Would you be able to, tell your client, or have you had situations where your client has declined or refused to have one of those involvements in that type of situation?
Well, it's a very good question, and I'm just going to reframe it by saying that under what circumstances would one not want such a report? Any one of the three, by the way. And so the answer is where we as lawyers have a case where a parent is either making or receiving very severe allegations regarding parenting. And the parenting allegations all occurred under the roof of the home, and nobody else was there, just the parents and the children. And one parent is making very disparaging, severe, undermining allegations about the fitness of a parent to be able to care for a child. In a situation like that, absent expert evidence, the kind of expert evidence we've just described, we've got this very dark cloud, and nobody knows whether to believe it or not. There's no criminal charges often. There's no outside evidence. There's no witnesses. There's no videos. One person says alcoholism, drug use, punishment, physical violence. How do we know? One word against the other. So along comes the benefit of the Voice of the Child report or the Section 30 analysis that provides the in-depth internal observation, analysis, and interviews of children to comment on this. There have been cases where a person says the kids witnessed this significant violence, and then once the children are interviewed and they're asked, repeatedly if they've ever seen this, and they deny it, or they say they never saw it. And in fact, these assessors are so smart in terms of how to ask the question. They don't often ask it straight on. They ask very indirect questions. Sometimes they use puzzles or drawings. Sometimes they will make reference to something completely unrelated and then bring it back to the question in order to try to uncover if there is any truth to these allegations. And then the analysis occurs, and then the report is produced. And so, to your question, there are very rare cases where this sort of information is necessary, but it's in that very small subset of cases where severe allegations are made that the only way out of this is by getting that independent, reliable, expert evidence stemming from the interviews of the children. By the way, it's interviews and observations. So back to the subject of reliability. When you ask a child a question at 3 or 4 or 5 different visits, their body language and their eye contact is the sort of thing that the assessor is also observing, relying upon, and reporting on. And there's been many cases where the assessor reports on the fact that the child is covering for a parent or is afraid of disclosing it. And the assessor is observing the child shrink or look away or look at the door or look at the phone when the question is being asked, because the child is worried that this information is going to be revealed and that the child is going to suffer the consequences of revealing that information. And so it's in those very rare cases where these assessments or reports are so critical. Having said that, it's very rare to involve a voice of the child report or a parenting assessment in a separation or divorce, because most of the time parents really want to resolve their affairs. They do not want to spend thousands of dollars and months and involve strangers in the children's lives who are going to interview them and ask them questions, ask them difficult questions. Many parents are concerned that unto itself will scar the children, far more scarring from having professionals poke and prod them than to simply reach a resolution and move on with their lives. And we live in a world right now where fathers, today more than ever before, are very actively involved in children's lives. And many moms actually appreciate that and applaud that, prior to separation and divorce, of course. And so because of the active involvement of fathers in children's lives during the duration of the marriage, it's less likely, and in fact, we've seen fewer cases where there is such a high level of conflict over what the parenting schedule will be, because of the fact that both parents recognize that the children have benefited from having both parents in their lives prior to separation, and so therefore after separation. So let me ask you a question, Leanne. Have you ever had a situation where you have had to object to the involvement of a third-party professional to interview the children?
I have not. I've had situations where it was the other party who raised it and perhaps wanted it more than my client. But my clients, when it has been raised, have always agreed. So I've never had a situation where I was forced to object to it. One of the other things as we've been talking that I was thinking of too, that I didn't mention when I was going through various options with respect to the children, is we haven't touched upon the Children's Aid Society, which of course gets involved in certain cases, and they're not, per se a voice of the child. They have their own mandate in ensuring that children are safe and healthy and being cared for properly. But there are a number of cases out there where the Children's Aid is involved on varying levels, and They, are another party that would interview children and meet with children, and if they're involved in the case, they can also have some influence on what goes on.
And I want to wrap up by indicating that all of these tools are in fact tools in the toolbox of separation and divorce to uncover what the children want. But at the end of the day, there's a saying in family law, and it's children have a voice, but not a choice. And the judges, the lawyers, the mediators, and oftentimes the parents recognize that it's important to know what the children want, but it's not determinative. And at the end of the day, it may very well be that during the course of the marriage, one parent has done a very good job creating a wedge between the children and the other parent. And just because during the marriage, one parent was more involved and the other parent was less involved, does not necessarily mean, ipso facto, that the post-separation schedule will match the pre-separation routines and relationships. And in fact, there are many cases where they have maintained that arrangement quietly, tacitly, under protest, which is what leads to the separation in the end. Because some people break up because of parental conflict. And in situations like that, the pre-separation relationship is not necessarily determinative of the post-separation relationship. And in fact, in the most extreme cases, there are cases where the children are very bonded to one parent and are fearful of the other parent. And in some of those cases, we call it parental alienation. And in those situations, there have been many cases in court where the judges, after they get these assessment reports, make the decision to literally tear away the children from the favored parent, block the relationship between the children and the favored parent for a period of time, while they place the children with the estranged parent in order to remedy that very problem. So, to bring it to a full close, the center point in parenting disputes is the children. And if the center point of the parenting dispute is the children's views and preferences are indeed relevant, if, of course, they are reliable, if they're weighty, if those views and preferences can be reasonably ascertained. And in most cases, it's not needed because parents will act responsibly. But in those cases where it is needed, in those extreme cases, these tools to extract that, to be able to rely upon it, are extremely important. And we are very lucky in Ontario, because other jurisdictions don't have this, to have a government office paid for by our tax dollars that provide those tools. The Office of the Children's Lawyer services thousands of disputing parents every year with these types of reports. And so with that said, we in the family law field, and you viewers who may or may not be involved in family law disputes, we're very fortunate to be in a jurisdiction where these sorts of tools are available to us.
Definitely. Well said. So thank you, Steve, for joining us. And thank you to our listeners for tuning in. And we'll see you here again next week.
You got it. Bye, everybody.
Bye.